go to law school to avoid science and math, right? I mean, most people do this. The judges don't want to deal with these cases. And so, yes, they will take their responsibility seriously, but to the extent that they can punt it off to the jury, I think that's going to be the inclination.
Hey everyone, welcome back to another episode of On the Stand with Ashish Arun. Today we have the privilege of speaking with one of the foremost scholars in evidence law, Professor Edwad K. Cheng. Professor Cheng holds the prestigious Hess Chair in Law at Vanderbilt University and is a leading authority on the intersection of law and statistics. With a PhD in statistics from Columbia and a JD from Harvard, his work has shaped the way courts, lawyers, and scholars think about expert testimony, scientific evidence, and admissibility standards. He is also a co-author of the influential multi-volume treatise, Modern Scientific Evidence, which has been a go-to resource for legal professionals and academics alike. Today we'll be discussing his latest research on what he calls expert histories, a fascinating and critical examination of how courts consider an expert's past record of admissibility when deciding whether to allow their testimony. In this forthcoming article in the Columbia Science and Technology Law Review, Professor Cheng explores what he describes as the mark of exclusion, the idea that a single adverse ruling on an expert's credibility can have a lasting and sometimes career-ending effect. His work raises important questions about fairness, judicial decision-making, and how experts can navigate this hidden aspect of the courtroom. Beyond his scholarship, Dr. Cheng is a sought-after speaker, a frequent contributor to legal symposia, and the creator of Excited Utterance, a widely respected podcast on evidence law. So we are truly honored to have him today on the show to discuss his research, his broader views on the future of expert testimony, and his advice for those working in this space. Professor Cheng, welcome to the show.
Thanks for having me. Really appreciate it.
It's a pleasure. So let me start by asking about your background and how you really got interested in evidence law and specifically expert witness law.
So I have a science background, and one of the things that made me become a law professor was an interest in toxic torts. So the interest in, I think, expert evidence has always been there. There's a kind of fascination with how lay people, lay jurors, lay judges, how we can teach them about science in a very sort of short amount of time. And then I think the interest in evidence law came from that. It made sense that as a former STEM scientist person, I was interested in how we learn about the world. And evidence is the way that legal people learn about the world.
And you've also published a lot, and a lot of your publications are based on empirical studies. So how did that happen, and where did that interest come?
Well, so I think that all comes from the evidence side of things. Before I went to law school, I had something of a statistics background. It wasn't a very deep one, but whenever I'm faced with an empirical question, my natural instinct is to attack it in some empirical way. And so one of the things that happened early in my career was I was doing a lot of empirical type work, or at least I gravitated in that way. I was a little bit uneasy about doing a lot of empirical work based on whatever I learned in my undergraduate statistics class. And that led to me doing graduate work in statistics. A lot of it was about just simply feeling comfortable with the underlying models that I was using. But then also it ultimately related very nicely with evidence law, because to the extent that statistical inference is one way, again, about learning about how the world works, it's kind of how science works, we can port those ideas back over to the legal context.
And you've also one of the co-authors of the Modern Scientific Evidence, the treatise on evidence law. And I specifically remember that is how about 13 years ago, I got in touch with you when I was trying to do the Expert Witness Chronicle, a legal magazine. But we won't talk about that book today. We'll talk about the new article that you've written, and it's going to be published. It's forthcoming in the Columbia Science and Technology Law Review on expert histories. And you start this article with the sentence that testifying experts often express worry about being excluded in a case. As one of the co-owners of Expert Witness Profiler, I think truer words have never been said before. Like, testifying experts, it puts the fear of God in them if their testimony gets excluded. So, can you please talk to us about this paper and, what led you to doing this research, and what were some of the key findings that that came out from this endeavor?
So, in terms of the genesis of the article, I often say, or it's often been the case in my career, that some of the best article ideas comes from the casual conversations that you have with others. And so some of the genesis of this article came from discussions I had with my dissertation advisor, who is a statistician and often testifies as an expert witness. In fact, the way we got to know each other was that he in class one day said, "Oh, I'm an expert witness in a toxic tort case." And I went up and talked to him and I said, "Hey, by the way, I study this from exactly the opposite angle, right? You're the statistician being the expert. I'm the lawyer studying how we deal with experts." And he had remarked to me that when he was excluded once, and it's a sort of very strange way for him to be excluded, this sort of prominent statistician, why would he be excluded? But he was excluded once, and the attorneys effectively told him, "Look, there's kind of a cooling off period. We can't use you right away because you've been excluded. And so we're going to take it easy for a little while." And so that, I think, was the very genesis of the idea. And then talking to other colleagues who have had professional experience hiring and dealing with experts in various kinds of cases, they've often talked to me. Edith Beardson at Temple is one of those conversations I had. And Edith mentioned to me that, well, when she was in practice, attorneys paid attention to how often an expert would get excluded, but then the experts themselves were in fact terrified of being excluded because they thought that after that they would never be able to testify again. And this is sort of, when I say the mark of exclusion in my paper, it's kind of like the scarlet letter is the metaphor that I was thinking, right? You sort of get branded as someone who is excluded, and now no one actually wants to touch you. So that's really where the article or the idea for the article came from. And then, as with a lot of these observations, sometimes they just sit in your head for a long time. You don't really know how to get at it. You just make a note of it, and you think it's an interesting phenomenon. And then, I think this was 2020, it was in the middle of the pandemic, and we're all sitting around thinking about what we should be doing. It occurred to me that maybe I could use the service that you and Miles have, Expert Profiler, to get at this problem. In many ways, I started to think, well, how could I get data on an expert's history? And I thought, oh, there is this service out there that actually does research on an expert's history. And so that's the beginning of the paper. Now, I think you did ask where that study went after that. And so let me back up for a minute. So I used the data that you provided on various experts that you have done research on.
Yeah.
And the basic empirical question was, does an expert's exclusion in the past change the likelihood that the expert will be excluded in the future? And obviously, an exclusion in the past may change the basic information we have about the reliability of the expert. But in addition to that change in the information on reliability, does the mere fact that you have an exclusion create an increased risk of exclusion in the future. So in other words, is there any kind of snowball effect that occurs with exclusions? And just to make a long story short, the basic conclusion of the study was that I was able to find quite a robust effect suggesting that experts were in fact more likely to be excluded after they had suffered a previous exclusion. But one interesting part about the results was that the effect ends up being quite small. So it's very robust, but the change in the percentage, if one were to try to translate, it's like an increase of 3% or 4% that's going on. And that's a kind of interesting finding. So on the one hand, yes, I think to say that there would be an effect makes a lot of sense. The bigger mystery, I think, is why is the effect so small?
I completely agree that it has an effect. And this is not based on the empirical study, but we have been studying individual experts for a good 15, 16 years now. And this is something that we have seen. Experts are definitely worried about being excluded. Attorneys, when they are retaining an expert, don't want to retain an expert who has been excluded multiple times. But like you said, I think in my perspective, it depends as to why the expert was excluded. Like, I'll give you an example. We interviewed this particular expert on the podcast a few episodes ago, and it's out on YouTube, where this particular expert, he's a trucking expert, and he was excluded in a case. It wasn't even his fault, but he was excluded. But then he was asked about that exclusion in a later case. And he was really worried that now that this exclusion has happened, this is going to keep following him in every case where he is retained. And if the news goes out, attorneys would not want to touch him with a 10-foot pole. So even though he was able to get some reprieve from the judge on his exclusion, because it wasn't really his fault, but there are ways that it would impact. Now, from a attorney's point of view, this is what the study is suggesting. But what's your personal take on this whole effect of exclusion that you saw in your study, that it does have an impact? But should it really have an impact? As an expert, if I'm asking you, okay, I got excluded, but maybe it was because attorney did not comply with Rule 26, which is the disclosure deadline law, and it was a late disclosure and my testimony was excluded. That's also an exclusion, but it's not under Rule 702 or the Daubert standard. Or maybe a part of my testimony was excluded. They did not strike all of it. I gave 10 opinions. 2 were excluded, that, okay, these were not under my expertise. So do you really think that should it impact my credibility and my retainability as an expert going forward?
Well, your observation does 2 things. I think one thing is it's suggesting an answer to why the effect is small, which is that exclusion within itself contains lots of different things. So the data is very noisy.
Yeah.
The expert is excluded. Why is the expert excluded? Could be a lot of different things. Could be procedural problems. Could be that the court decides to exclude on one ground but not another ground. And the study sort of, I try, but it's actually very hard to get a sense of exactly why the expert is excluded. And so the reason for the 3% may be that, actually, and we don't know this, but I could speculate, if you're excluded on reliability grounds, that's a much bigger jump than if you're excluded for other reasons, because then the court knows that there isn't an issue. So I think that explains some of the outcome in the case. Your other question is, to what extent should we do this to other experts? It seems to me that the snowball effect normatively is a bad thing. I don't think what you want is, well, if I get excluded, now suddenly I'm going to be unable to testify in the future. The kind of path dependency is not actually informative. That's almost psychological in nature more than anything else. But the underlying information, and this is what the study was trying to separate in some ways, the underlying information seems to be a good idea, that you have courts that are faced with hard questions about scientific reliability. And this goes back to the original question that I asked, which is, how do you get lay judges and lay jurors to deal with science? They need something to hold on to when they're making these determinations. And having a bit of a wisdom of crowds aspect here, where you borrow strength from your colleagues and you try to be consistent across the board on how you handle an expert, I think there's merit in doing that. Now, this also raises another noisy aspect of the data as well, which is that if the expert gets excluded once before on the exact same issue, then of course it would be quite probative on a future case. But if the expert is doing something different and it's a different context, again, the probative value of the previous exclusion is going to be lower. So lots of noise, but the basic aspect of the case, or the basic aspect of the behavior, which is to use the expert history, I think is a good idea.
Yeah, in fact, you have cited this case in your paper, Little John versus Solar, where it looks like this is the exact same thing happened, because the expert Hendricks, who was excluded in all these different cases, seemed to be testifying on the physical, emotional, or economic effects of an inaccurate credit report. And it looks like that he was offering this opinion on something he was not qualified to offer. And he was offering that same opinion in all those cases. So when that happens, and then one judge has determined that you cannot testify on this, then it makes perfect sense for other courts to then borrow from the wisdom of the other courts, rather than trying to figure out, is he really qualified or not qualified?
Right. As opposed to, I'm just picking an example, but if you have a toxicologist and the toxicologist is talking about one particular poison that they did a study on, and now they're doing a different study, and the kinds of organisms that are involved are different, the probative value of the exclusion on the first case is now going to be far less than when you apply it to the second case.
So, do you have any advice for an expert who gets excluded and they hear about this exclusion, and usually the first reaction is panic? What do I do? I've been excluded. What are the 3-4 things you think an expert should do in such a scenario?
Well, it's interesting. So one thing that came out of the conference where I presented this paper was that experts are dynamic. So one of the limitations of the study is that it assumes that experts stay statically in the same spot. And that of course, is not what experts do, not only for financial business reasons, but also just because of professional integrity reasons. So you get excluded, you should think about why you got excluded and whether or not there were valid concerns about your testimony. So the learning process is, I think, something that we naturally do. And I would say that if you get excluded, you should think about why you got excluded and whether or not there's something about your testimony that perhaps was overly one-sided, not exploring limitations, right? What were the things that may have led to the exclusion? I think the other thing to also think about is, for a future case, how to explain what happened in the case in which you were excluded. So one thing that anecdotally I've learned is that when an expert gets excluded, basically in all future cases, you're going to get asked about that case. And then cross-examination is going to be, why were you excluded in that previous case? And you're going to have to come up with a good explanation in order to protect your ability to testify in future cases. I have less advice, or I don't have any personal experience with how do you make sure that you get hired again by other attorneys. I think that may be a trickier thing. And I don't know, Ashish, you and Miles may actually have better advice on that score than I do.
So there's this thing that experts should not give legal conclusions in their testimony. And a lot of times some experts do, and that's when the courts have excluded them on that ground. But do you think experts should at least know the law around expert witness testimony, like Rule 702 or whatever state-specific laws apply to the testimony of an expert, the Daubert standard? What's your take on that?
Yeah, so obviously the expert shouldn't testify about the law, and there's plenty of law saying that the expert can't do that. But I think it's only responsible to know what the governing law is about your own testimony. And so I have a small story about this. So one of the few times that I've actually been a testifying expert, I was deposed, and during the deposition, I, in many ways, knew exactly where the attorneys were going. So in this particular chess match, because what I do is I actually spend a lot of time thinking about this, I kind of knew what the questions were coming up. And I didn't get this sense, but certainly my attorney thought that the other attorney became increasingly frustrated with the exchange because I kind of knew what was going on, and I could frame everything the way that I wanted to frame my testimony. And it's not to say that, therefore I was per se manipulating the outcome, but it's that how you express yourself matters, and knowing what the boxes are that the attorney is trying to check or not check in the case of an opposing attorney is really important for you. So I think it's actually a very important thing for all experts to know. It's not just your expertise, but you also have to know who your audience is and what they're looking for. And that's just good teaching. It's good pedagogy that you need to know where your audience or what background your audience has, and you need to know what your audience is trying to get out of the interaction so that you can express yourself well.
Yeah, I think that's a great tip for experts, not just to know the law, but to also try and preempt the questions and not to manipulate your testimony, but to maybe preempt the manipulation from the other side. I think that's a great tip for all experts and attorneys who are working with experts. So a lot of experts have now started putting this clause in their retainer agreement that if there is a Daubert challenge to my testimony, it's the attorney's duty to notify me and allow me to look at the grounds on which they are challenging so I can help prepare a response. So I think that is something that more and more experts need to do, because like you said, that experts are asked, why were you excluded in that previous case? A lot of experts, and this is something that's based on my personal experience talking to experts, and a lot of times experts would also order their own background reports from us. And they would be surprised that, oh, my testimony was challenged in this case also. Oh, I had no idea about it. So this is something that's very prevalent, where an expert would submit a report and then would never hear from the attorney. And later they would learn that there was a challenge and the testimony was excluded. But a lot of times they would just not know about it.
So I don't do a lot of expert testimony myself, although I have taken on some of these opportunities because in some ways so that I could learn how it actually works on the other end. And I too have had the experience where you take the deposition, clearly there's a Daubert challenge, and you never hear about what actually happens in the case ever again. And sometimes, so in the case, I actually, it's in some sense inspired by your stories, I went and looked up quite deeply what actually happened in the case. Case got dismissed on other grounds, and in fact, the court says, well, we don't reach the Daubert challenge because we're going to grant summary judgment on other grounds, and like that's fine, but experts, I think, often don't get told about that because that's in some ways the last thing that the attorney is worrying about at that point, because there wasn't even there wasn't even actually a resolution on that ground, and they're trying to
Yeah.
save their case in other ways rather than notifying the expert about what happened to the challenge.
And that happens more times than, like we would like to, because like you have noted in your paper also, that the outcomes were not available in most of the cases. And in fact, in our data set as well, and when we research experts, a lot of times we have this section called disposition. And we give this graph where for each case we have a disposition, what was the disposition on the expert's testimony. And a lot of times it would be outcome unknown, because we would look at the docket sheet, we will find a motion to exclude the expert, but then after that we would not find an order. And a lot of times, forget the order, we would not even find any references to that motion in the docket sheet of the case. And then we'll eventually see, okay, the case settled, or the case got dismissed, or they went to summary judgment, they never ruled on the outcome. So again, we don't know the outcomes in a lot of cases, which is why researching experts can be a little tricky. And that's an understatement, but that allows us to be in this business and try and help experts and attorneys both. But do you really feel that judges look into the background of an expert when there's a Daubert motion that they are looking at? Like, are judges doing that kind of research?
So it's kind of funny. Some of the answer is no, based on pure judicial philosophy. So if a judge's view is, I only call balls and strikes, or I should not be doing any independent research on my own, then the judge normatively is going to say, I'm not going to look into this expert any more than the opposing party is. And so you already can exclude a large swath of judges on that ground. I think is just from a practical standpoint, I have my doubts whether or not a judge is actually going to start doing research on the expert, primarily for the research difficulties that you were pointing to. When I clerked now 25 years ago, but I certainly didn't have any particular inclination, regardless of the judicial philosophy point, whether or not I was going to actually look up the expert's history for my judge, because that seems to be an enormous amount of time, which I do not have. So I think this is going to be one of those cases where it's incumbent on the opposing party to figure out what the expert's history is. And in fact, frankly, I think it's also incumbent on the proponent party to figure out what the history is of the expert, because sometimes experts don't know, which is our previous conversation. The expert doesn't know what happened in the previous cases, and so you don't want to get blindsided either in deposition or at any point when there's cross-examination that the expert actually has this checkered past which you didn't know about.
So some experts actually feel that it's better to not know. So at least you have plausible deniability, that if they ask, like, have you ever been excluded? And they can say, oh, to the best of my knowledge, I have been not. But then if you're in front of a jury or you're on camera for a deposition and they bring out these orders after orders that, hey, you've been challenged, excluded here, excluded there, it's better to be prepared.
I think sometimes it's human nature not to want to know whether or not there was a negative result. I think in some ways it makes us feel better about ourselves. It's often not a good policy, because then you don't know how to respond to those kinds of questions.
Like people don't want to get their blood work done because they're like, oh, I don't want to find out what's going on. If my cholesterol's high, don't tell me.
Well, I mean, look, and it also, I think, goes back to the point I made earlier in our discussion about learning. We don't learn unless we fail. And so if you get excluded, it's actually not a bad opportunity for you to figure out how you can make it better. If you stick your head in the sand, you don't actually know what you did wrong. Same goes for teaching. We all like good teaching evaluations, but it's the bad teaching evaluations that kind of enable you to self-reflect and think about how you can do things better.
No, and one more point I wanted to make before I go to the next segment. A lot of times we've seen that experts who would be qualified in a particular area will be very cautious about not picking cases that are outside their area of expertise, especially in fields like medicine, where you may be a doctor, but you may not be a doctor on the subject which is involved in the case. But some experts make the mistake of picking something that's on the borderline. And they'll be like, oh, I have this case. It's probably good money, and it may not be squarely within my area of expertise, but maybe I can get by. And those are the kinds of cases where we see a lot of exclusions. Because then the judge will be like, okay, you are an expert on this, but you still cannot testify on these issues. So that's something that experts need to be very about. Did you come across any cases in your study where experts were found picking cases outside their area of expertise and were then got excluded?
So the study did not focus on this. And again, it's probably could have dug into some of the notes in the data set that were there on exactly the grounds for the exclusion. Yeah, it's an interesting thing. The grounds for excluding an expert on this, well, you're not exactly in your area or outside your area. I often teach in my evidence class that qualifications are usually handled with a pretty light touch, or at least in my reading of many Daubert challenges over the years. And I think oftentimes it's because of professional courtesy, right? Judges don't want to tell an expert that they are incompetent and they're not qualified at all. But if you stray outside of your box, that does offer an opportunity for the judge to both be magnanimous. Well, we acknowledge that you are an expert on X, but that you're not qualified on Y. And so that gives the judge an easy path to exclusion, even, and in fact, without any reliability analysis, which is a very difficult thing to do. They just basically say, you're in this box and not in the other box, and so we're going to exclude you on those grounds. I should mention, though, that from a normative perspective, whether or not this is good for the legal system, it is a little bit tricky because we don't want experts who are cabined into very specific subject areas. So take, for example, a statistician. A statistician's skills can be used in a wide variety of substantive areas and still provide considerable value added to a legal proceeding, even though they don't normally work in the food service industry, right? So you bring in a statistician to work on a food service case. They've never done a food service case. That statistician is still perfectly qualified to do that study as long as it's sufficiently limited. And you worry sometimes that courts will exclude on those kinds of grounds, which I think is not the poor fit should really be a methodological question, not one about topic area.
So let me ask you about the 702 amendment that happened last year, where they changed one of the requirements that the expert should reliably apply the principles and methods to the facts of the case. They changed it to the expert's opinion reflects a reliable application. And when the amendment came in, and when we were looking at the background of the amendment and the committee notes and all, it felt like a lot of judges were passing the buck when it came to determining the admissibility of an expert's testimony. They were like, it looks okay. And these challenges, they, like the specific phrase, we keep seeing this in orders on Daubert motions, that the challenge goes to the weight and not the admissibility of the expert's opinion. And this is something when the judges are, like not sure, or they feel that, okay, this should be admitted. Let the jury figure out if they want to give weight to this opinion or not. So to tackle that, they brought in the amendment. And because everybody felt that, okay, experts are getting very lenient treatment. And like almost a year and like 13 months have passed since the amendment kicked in. And we expected that we'll see more Daubert challenges and stricter scrutiny of the expert's testimony. And a few articles have come out from lawyers. Some lawyers have done some commentary on this. And I myself was looking at opinions that have come out in the last 13 months. And I simply, out of curiosity, ran a Boolean query for that phrase that goes to the weight and not the admissibility. And more than 50% of the orders had that phrase. And which clearly says that a lot of judges are not applying the amended Rule 702. The burden is still being passed to the jury that, okay, I, as a judge who's fairly educated, I'm not going to determine this. You, the jury, 12 or say, whatever the size is, you figure this out. What's your take on this, and why do you think that is? Like, why are judges not interested in applying this standard properly?
So I think there are two ideas here. So one is, first of all, I should say that as an academic, I'm a bit of a heretic on Rule 702. Early in my career, co-author Daubert and I wrote an article about whether it mattered whether a state followed Daubert or Frye. And Daubert, of course, has this multi-factor test. Frye has, this general acceptance test. And you would think that in terms of actual application, it would make a difference because you have different texts and you're applying different law. And our conclusion in that case was, at least empirically, we didn't really see any obvious difference between Frye and Daubert jurisdictions. There were limitations to that study, so I should say that, put that out front. But the theory that we had that drove that study was that it wasn't, the Daubert revolution was not in the specific test, but in the idea that judges had to be worried about unreliable expert testimony. And that this idea of judge as gatekeeper, the idea that there is such a thing as junk science, that's the thing that mattered. And so the reason why I say that I'm a bit of a heretic is that I feel like what's really going on in this has nothing to do with the actual language that's floating around in 702. It's really about this general idea that judges have to look carefully at the expert's testimony and assess whether or not it's any good. And that means that you shouldn't, it's not surprising to me that you don't really see a huge effect because of this language change. It's also that I think in some ways it makes a lot of sense because expert testimony is so broad and varied that no multi-factor test, and I realize 702 doesn't have a multi-factor test, but judges keep going back to Daubert. No multi-factor test is going to capture what reliability is. And that's why you mentioned the treatise that I'm a part of. In the treatise, we talk about the Daubert factors as incantation sometimes, that judges will chant the Daubert factors because they feel like they have to do that. And then whether or not it makes sense to apply it or not, they sort of go off on their own and they basically impose a rigor test or a hard look test, or sometimes I describe it to my students as the smell test. Is the expert just a hired gun and just arriving at whatever conclusion the client wants? Or is the expert actually using the tools that the expert has been trained in? So all of that is to say that as a general rule, it would make sense that small language changes in Rule 702 are not going to actually change judicial behavior. So that's like one piece. I think the other piece too is just that in my conversation with judges, there's a very small minority who are really excited about Daubert, and they think that they can do a lot of good or they can probe these things themselves. And we can get into whether or not that's a good idea or not, but there's a small amount of judges that do this. The vast majority of judges, and let's face it, people go to law school to avoid science and math, right? I mean, most people do this. The judges don't want to deal with these cases. And so, yes, they will take their responsibility seriously, but to the extent that they can punt it off to the jury, I think that's going to be the inclination. And so, again, another reason why you see a lot of this language that it goes to weight and non-admissibility.
And as a follow up, do you see AI having any role in helping judges, one, figure out the science that they are unable to figure out or they don't want to figure out, making it easier for them to quickly pull up some concepts that the expert is throwing out and ask AI to explain it to them in simple words? That's one. Or maybe any other way that you think AI will have a role to play in how judges look at expert testimony?
So it's a very interesting question. So in terms of judicial education, gotta imagine that AI can be helpful. But on the other hand, the question is, how much are judges going to trust the output of AI? I think we're all still in that phase where we're trying to figure out how trustworthy the source is. And judges are, if anything, small c conservative, right? They do not want to try out new things. So I think that could be a difficult sell. I earlier said that I was a heretic on one issue in expert testimony, so I'll be a heretic in a different issue too, right? So one of my proposals, which is clearly not Rule 702, but one of my proposals is that I think we should spend a lot more time focused on consensus or expert community consensus as opposed to trying to figure this stuff out on our own. So this really relates to the original puzzle, which is how do lay people engage with questions that involve expertise. And so one of my proposals is, well, what you do is you don't try to insert yourself into the substantive assessment of the evidence. What you instead try to do is figure out what experts generally in the field think about this topic. So it moves you away from the specifically hired expert and moves you to a kind of community-based way of looking at expertise. And actually, I think AI might be a very powerful tool in figuring out community views on a subject, because that's exactly, in some ways, how these models work. You're trying to take a large amount of literature and data and you're going to crunch it down into something that is common. That may actually be an excellent tool for doing that.
So would you say that if you look at the general acceptability of the community, then wouldn't we be going a little towards the Fry standard?
Yeah, it's actually a more radicalized Fry standard. So if you think about how Fry works, Fry says that the judge gets to allow an expert in or out based on general acceptance. And by the way, in terms of historically, it was applied in a much more narrow context. It was really about novel techniques as opposed to conclusions. But if we just take the idea of general acceptance generally, the Fry standard says the judge decides about general acceptance, and then if it is generally accepted, that testimony goes in front of the jury, and then the jury again can do whatever the jury wants, because the jury is the ultimate fact finder. And my proposal is actually not that. It's actually that the jury should try to figure out exactly what the generally accepted view is, and then should defer to that generally accepted view. So, as I said, it's a radicalized Fry standard. It's taking Fry to its ultimate conclusion. And I just think from an epistemological standpoint, I think it makes more sense to do that than what we do now. But as I said, in terms of the legal system, this is a wacky idea. Nobody actually does this at the moment.
But I think it can be very interesting, like if that is the direction that judges and jury try to take. So talking about directions, Professor Cheng, where are you heading next in terms of your next research paper? What's on the cards?
Well, there's a whole bunch of stuff going on as always. I do have a kind of long-term project thinking about this deference to consensus idea. So I've written 2 papers on this, one long, one short, and there's a book contract on this. So I would like to spin this off. There are some evidentiary papers about applying evidence rules in contexts other than trials. A lot of our litigation today ends up in administrative courts. And what should the evidence rules look like in those contexts? And then there's a forthcoming article which is kind of in the works about evidence that is controlled by one party. So something that my co-author and I call asymmetric evidence. And the idea there is that most evidence we think, or at least I think the working assumption in the legal system is that both parties have access to the evidence, and so the adversarial process works well, right? So if you have a car accident, there are going to be eyewitnesses. Well, both sides are going to try to grab at those resources, and you can get truth that way. But when you have evidence that is only held by and known by one party, I think in some ways discovery rules try to get at this some, but not, they're imperfect. When you have asymmetric evidence in this way, the evidence that shows up will tend to only show up when it supports one side. And that asymmetry creates problems for the truth-seeking process, because in many ways you can think about this as selection bias in a statistical study. You only see data that supports one side. That obviously is going to throw off your results. And so I think that paper has some interesting theoretical aspects.
These are really, really interesting things that you're looking into. I'd be very interested in learning about what you find about evidence in administrative courts, because even when it comes to experts, the same standards don't apply when experts are working in administrative courts. And that's one aspect that we keep seeing, where the administrative law judges are giving their opinions that the rules of evidence don't apply. And then they factor that in, and then they take more leeway in how they would rule on an expert's testimony. So I'm looking forward to reading all these papers that you're working on. This was an absolute pleasure and a great learning experience for me. And I'm really glad we were able to do this. I'm looking forward to the paper. Any last comments that you'd want to make to our listeners?
Just, I want to thank you. It was likewise a real pleasure to talk to you. Always a great time talking about scientific and expert evidence, and having someone with your expertise makes it all the better.
Thank you so much, Professor Cheng, and we'll hope to speak to you soon. If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.